Welcome to Respiratory 170. Today we're talking about ethical and legal implications of practice. Here are the learning objectives for today. We're going to be summarizing the philosophical foundations of ethics and explaining what constitutes an ethical dilemma and how such dilemmas arise in healthcare. We'll be describing how professional codes of ethics apply to ethical decision-making and explaining how traditional ethics principles are useful in resolving dilemmas. We'll be describing the information that should be gathered before making an ethical decision and how the systems of civil and criminal law differ. We'll also be describing what constitutes professional malpractice and negligence and explaining how respiratory therapists can become liable for wrongful acts. We'll also be listing the elements that constitute a practice act and explain how licensing affects legal responsibility and liability. We'll be describing how changes in healthcare delivery have shaped the ethical and legal aspects of practice and the basic elements of the Health Insurance Portability and Accountability Act of 1996 that you probably know it as HIPAA. We'll be discussing this Patient Protection and Affordable Care Act and summarizing the basic elements of the National Labor Relations Act and the False Claims Act. And we'll also describe the role of advance directives and living wills in healthcare. RTs regularly find themselves in circumstances that require them to make choices or take actions that have ethical and legal consequences. In society, ethics and law help maintain order, stability, and accountability. In professional practices, ethics guide RTs in carrying out their duties in a moral way. Law establishes the minimum legal standards to which practitioners must adhere. Although not always the case, ethical practice may require a standard above that of legal practice. An illegal act violates the standards of conduct set down for all citizens, whereas ethical misconduct usually relates to violations of professional and ethical norms established by the profession as a whole. Punishment for ethical misconduct ranges from a loss of professional standing to expulsion from the profession or professional societies. Punishment by the state board in one state will usually result in reciprocal discipline in any other state where a practitioner holds a license to practice. In some cases, particularly those involving patient injury, ethical misconduct leading to state sanctions on the right to practice and legal consequences in the form of criminal penalties or civil judgments may result from the same incident. The distinction between illegal acts and unethical behavior is not always obvious, but it is straightforward. A given act may fit any one of the following categories, depending on the circumstances and the ethical orientation of the person involved: ethical and legal, unethical but legal, ethical but illegal, or unethical and illegal. Philosophy can be defined as the love of wisdom and the pursuit of knowledge concerning humankind, nature, and reality. Philosophy is often divided into several branches: metaphysics, epistemology, ethics, aesthetics, logic, and political philosophy, for example. Now, ethics is one of the disciplines of philosophy, which is primarily concerned with the question of how we should act. Ethics can be described philosophically as a moral principle that supplements the golden rule and can be summed up by a commitment to respect the humanity in people. Now, RTs are faced with ethical dilemmas and legal issues associated with patient expectations, staffing, quality of care. Now, some ethical dilemmas and legal issues can include the rationing of care, dealing with conflicts associated with third-party imposed standards of care, and delivery of the appropriate standard of care in the face of cost constraints and corporate influence. Now, staffing issues continue to be a problem and contribute to many of the ethical and legal concerns that we face today. As our profession continues to grow and mature, and fewer resources are available, these challenges are likely to increase. Now, a code of ethics is an essential part of any profession that claims to be self-regulating. The AARC has state a statement of ethics and professional conduct that can be seen here on this slide. This code seeks to establish parameters of behavior for members of our profession. Now, this provides moral obligations to impose ethical duties on its therapists. And in addition to moral obligations that ethical duties impose on RTs, ethical obligations are often cited in legal proceedings. For example, if you're ever accused of actions that would violate the ethical duties of our profession, if you can show ignorance of the ethical standards, it can help your case. The Code of Ethics also provides the foundation for all ethical behavior in addition to moral behavior. And the ethical theories and ethical principles can consist of two components. It's composed of a professional duty and a patient right. Now, most ethicists agree that principles like autonomy, veracity, non-malfeasance, beneficence, confidentiality, justice, and role fidelity are the primary guiding principles in ethical decision-making. Now, in each of these duties that I just spoke about, there is a reciprocal of patient right. So the principle of autonomy, which is what we're going to be talking about next, acknowledges that the personal liberty of patients and their right to decide their own course of treatment and follow through on a plan on which they freely agree. So it's from this principle that rules about informed consent are derived. So, for example, before any medical interventions can be performed, that patient has to be informed about what's being done, as well as the risks and benefits of that particular treatment. Now, then they can exercise their autonomy and freely decide to either give or withhold consent for that procedure. So under the principle of autonomy, the use of deception or coercion by any healthcare worker to get a patient to give consent is considered unethical. Now, the principle of veracity, which is accuracy or truthfulness, is often linked closely to autonomy, especially in the area of informed consent. Now, veracity requires that the healthcare provider tell the consenting person or the patient the whole truth about the choices inherent in your medical care. So this means that you have to provide not only information about the benefits of a particular course of action, but also what can go wrong with that procedure and what kinds of complications can happen. So problems with this revolve around issues like benevolent deception. So benevolent deception is where the truth is withheld from the patient for their supposed own good. So other than like pediatrics with rare cases where the truth would lead to harm, like if you think that the patient might cause suicide if they know the truth, you should always provide the truth in as pleasant a manner as possible, and that's almost, that's always the best policy. So truth-telling really involves like making sure that you're always documenting everything accurately, and also telling, the patient exactly what's going on. So you don't want to mislead them. Now, the principle of malfeasance requires that you try to avoid harming patients. Now, this is sometimes difficult to uphold because sometimes drugs and procedures have, secondary side effects that can be perceived as harmful. Some procedures themselves carry risks of effects and complications, and you can't always predict them. So, for example, is it ethical to give a high dose of steroids to an asthmatic patient, knowing that there are potential harmful consequences of steroids? But you also know that there are a lot of helpful things that steroids can do. So you have to kind of weigh the good, is the good greater than the bad? Double effects are also common. So the key is what is the first intent. In this example, the first intent of giving the steroids is good because it's helping them to breathe, and the possible harmful effect is viewed as an unintended result. So your first intent is to help this patient to breathe, and as a complication, it may cause some unintended effect. Now, the principle of beneficence raises that do no harm requirement even higher. So we currently possess the technology to keep some patients alive well beyond any likelihood of meaningful recovery. So we can prolong that life, but not the ability to restore any quality of that prolonged existence. So because of this, advanced directives have really become something that we have strived for. So advanced directives allow a patient to give direction to healthcare providers about treatment choices in circumstances in which the patient can no longer be able to decide for themselves competently. Now, there are two types of advanced directives that are currently available, and those are the living will and the durable power of attorney. So a durable power of attorney for healthcare allows the patient to identify another person that can carry out their wishes with respect to healthcare decisions, should they be unable to express their wishes. Whereas a living will states that a person's healthcare preferences are made in writing. Now, as a result of a Patient Self-Determination Act of 1990, most of the states require that all healthcare agencies that receive federal reimbursement under Medicare and Medicaid have to provide all patients with information on advanced directives. The principle of confidentiality is based on the Hippocratic Oath. This principle requires healthcare providers to respect the patient's right to privacy. The main ethical issue surrounding this is whether more harm is done by occasionally violating its mandate or by always upholding it regardless of the consequences. Now, in certain situations, healthcare workers are permitted to share patients' medical history with others. And there is often a legal requirement to report certain things like child abuse, poisonings, industrial accidents, communicable diseases, blood transfusion reactions, narcotic use, and injuries caused with knives or guns. Failure to report cases of child abuse can even leave the practitioners legally liable for additional injuries that the child can sustain after being returned to the hostile environment. Gossiping about patients, however, is unprofessional, unethical, and in most cases illegal. Additionally, if you share information on social media, that will get you terminated and is also considered illegal. Now, exceptions to rules of confidentiality would be if you are caring for like a neighbor or a friend, would be if you're assigned as their provider and treating them as a respiratory therapist. But even then, it would be smarter if you, because of your close relationship, would be if you were asked to be excused from that case and ask someone else to take care of the clinical duties. And you said, look, it's a conflict of interest for me to care for this patient because I know them personally. But if you didn't, you would have access to only what was necessary for you in their chart because you are caring for that patient. You would not be allowed to just have free range to everything in their chart, only what you would need to care for that patient for that day. The principle of justice involves the fair distribution of care. Rising healthcare expectations, along with the decreased availability of care because of cost, are making this principle an important one for healthcare workers. Population trends and the increasing cost of pressure from Medicaid and Medicare will continue to make justice a challenge in delivering respiratory care. Efforts to achieve a balance between increasing healthcare expenses and cost pressure may lead to some form of rationing of the delivery of healthcare services. This type of justice is properly referred to as distributive justice. A second form of justice seen in healthcare is compensatory justice. This form of justice calls for the recovery of damages that were caused by the action of others. Damage awards in civil cases of medical malpractice or negligence are examples of compensatory justice. Compensatory justice often has been cited as playing a major role in increasing the cost of health care. However, the Congressional Budget Office estimates that less than 2% of the cost of health care is related to medical malpractice. When errors in practice cause patient injury or death, the possibility of professional liability results. Currently, many hospitals and healthcare organizations have adopted processes to lessen the risk of being sued. These quality review processes involve rapidly investigating sentinel events or an unanticipated event with serious physical or psychological consequences. And where errors are made, telling the patient that an error has occurred, followed by an immediate apology. In those instances where there is compensable injury, immediate compensation is offered. This process has reduced medical liability costs for some providers. Professional liability may contribute to increasing healthcare costs, and practitioners are caught in the middle. On one hand, they are required to keep costs down. On the other hand, they are faced with a level of consumerism that holds them accountable when medical errors result from scarcity of resources. Fortunately, very few cases actually wind up going to court, and most therapists will practice their entire career without ever going to court for a medical legal claim. Under our legal system, the law is divided into two broad classes, public law and civil law. Public law deals with the relationships of private parties and the government. The two major divisions of public law are criminal law and administrative law. Criminal law deals with acts or offenses against the welfare or safety of the public. Administrative law consists of the countless regulations set by government agencies. Healthcare facilities face a large number of administrative and agency rules that affect most every aspect of operation. Civil law is concerned with the recognition and enforcement of the rights and duties of private individuals and organizations. Civil courts, usually in the form of juries, decide between the two parties with regard to the degree of wrong and the level of awards required. The category of civil law that is best related to respiratory care is called tort law. A tort is a civil wrong other than a breach of contract committed against an individual or property for which a court provides a remedy in the form of an action for damages. Causes for the complaints may range from assault and battery to invasion of privacy. The basic function of torts are to keep the peace between individuals and to replace vengeance between individuals with a settlement. There are three basic forms of torts: negligent torts, intentional torts, and torts in which liability is assessed regardless of fault, as in the case of manufacturers of defective products. The basic difference between negligent and intentional torts is the element of intent. An intentional tort always involves a willful act that violates another person's interest. A negligent tort does not have to involve any action at all. Instead, a negligent tort can consist of an omission of an action or a failure to carry out a professional duty. The tort of negligence is concerned with the compensation of an individual for loss or damages arising from the unreasonable behavior of another. Professional negligence is different because the duty is defined by other professionals and for that reason requires expert testimony to establish. In negligence cases, the breach of duty often involves the matter of foreseeability. Cases in which the patient falls, is burned, is given the wrong medication, or is harmed by defects in an apparatus often revolve around the duty of the healthcare provider to anticipate the harm. For the tort of negligence to result in a liability, the breach of duty must be shown to be the cause of the injury. Causation revolves around whether the acts of negligence were the cause, in fact, and the legal cause of the damages. Causation, in fact, means simply that the negligent act of the caregiver caused the damages. Proximate causation, or legal causation, is based on foreseeability also. It tends to be a retrospective analysis. If an RT fails to check a ventilator as required, it is foreseeable that the patient could develop a compromised airway and sustain brain damage or die. Causation is often difficult to prove. Damages are another factor in negligent lawsuits. There are three kinds of damages: economic, non-economic, and punitive. Economic damages are awarded for economic loss. Non-economic damages include pain, suffering, disability, disfigurement, and loss of the enjoyment of life. Although economic damages can be guided by hard numbers, juries are often left to decide the value of a person's pain or suffering. Through tort reform laws, many states have limited the amounts that can be awarded for these elements of damage, but in some states those caps have been overturned. Punitive damages are damages that are awarded to punish wrongful conduct and discourage future unlawful conduct. Punitive damages are quite rare in medical negligence cases, except where alcohol or drug use by caregivers is involved, or where there is overwhelming negligence that is equivalent to intentional conduct. Some states also limit these damages. The elements of negligence are: the practitioner owes a duty to the patients. The practitioner breaches that duty. The breach of duty was the cause of damages, and damage or harm come to the patient. Malpractice as a form of negligence can involve professional misconduct, unreasonable lack of skill, or fidelity in professional duties, evil practice, or unethical conduct. There are three classifications of malpractice. Criminal malpractice includes crimes such as assault and battery, or euthanasia, which is handled in criminal court. Civil malpractice includes negligence or practice below a reasonable standard, also handled in civil court. Ethical malpractice includes violations of professional ethics and may result in censure or disciplinary actions by licensure boards. An intentional tort is a wrong perpetrated by someone who intends to do the act and possibly intends to do the harm. Unlike negligent torts, intentional torts are done with the goal of producing harm. Thus, in intentional torts, both actual and punitive damages may be awarded. Examples of intentional torts are acts that involve fraud, defamation of character, invasion of privacy, deceit, infliction of mental distress, and assault and battery. There are two general defenses against intentional torts. The first defense is that there was no intent to harm, and that only clinicians who engage in intentional conduct are liable. The second defense is that the patient gave consent for the procedure. If the patient consented to the action, knowing the risks involved, the practitioner would not be liable. In August of 1996, the U.S. Congress enacted HIPAA, which required, among other things, the establishment of standards for privacy of individually identifiable health information. These standards, which have become known as the Privacy Rule, strengthen the need to treat medical records and information as confidential. The primary goal of the rule was to strike a balance between protecting individuals' health information and not impeding the exchange of information needed to provide quality health care and protect the public's health and well-being. The Privacy Rule applies to all health plan providers, with some exceptions such as small employer plans with fewer than 50 participants administered solely by the employer, and healthcare clearinghouses. An example of a healthcare clearinghouse is an entity that processes insurance claims for payment. The basic goal of the Privacy Rule is to protect all individually identifiable health information, commonly referred to as protected health information. Protected information includes any record or information that would or could identify or reveal 1, an individual's past, present, or future physical or mental health or condition, or 2, the provision of health care to the individual, or 3, the past, present, or future payment for the provision of health care to the individual. Protected health information includes information in any format, which may include patient charts, whether they be electronic or paper, faxes, emails, or other records. The privacy rule specifies proper methods for the normal and appropriate conduct of healthcare treatment and business for all covered entities, individuals, and organizations that have a legitimate need to access the use of this information. Consent of the individual is not required for these covered entities. Simply because you know Mrs. Smith and her family, it's not sufficient to disclose this information. Written authorization is required by HIPAA. Verbal authorizations are not permitted because you have no way to prove that it happened, and the patient may later change his or her mind or forget who was authorized. Thus, until you know that the person is authorized in writing to receive the information, you may not disclose protected health information. Even though it may be difficult to tell a family member of a patient that you cannot share information over the phone, that is the answer that you must give. RTs are in a unique position to help protect patients from multiple harms. Sometimes RTs have a duty to speak out about problems or issues in the department under the protocols of the institution for addressing these concerns. However, sometimes the person who speaks out and identifies a problem faces retaliation. Several federal laws protect RTs who, because of their respect for ethical issues, speak out about wrongdoing. However, although these statutes may offer a cause of action for damages after a wrongful termination, they are generally ineffective in preventing termination. One should not assume that because a law says retaliation is unlawful, that individuals might nonetheless decide to take their chances and fire a whistleblower. In 2010, Congress passed the Patient Protection and Affordable Care Act in an attempt to reform healthcare. Challenges to the Patient Protection and Affordable Care Act are still finding their way through the state and federal courts, and results to date have been mixed. One thing that the statute did was improve whistleblower protections for hospital workers. Although the National Labor Relations Act is usually thought of as a union statute, the NLRA provides protections to hospital workers whether they are organized into a union or not. Specifically, the NLRA provides for protection where a worker engages in actions for the benefit of all employees. When an RT is discharged for such an offense, the RT has 180 days in which to make a complaint to the local office of the NLRA. No attorney is necessary to make such a complaint. Buried in the banking section of the United States Code is a little-known statute called the False Claims Act. Perhaps the most powerful part of this statute is the part that permits an employee with knowledge of fraud or false billing to file a lawsuit against the company or organization engaging in fraud. This also forbids making false claims against the government, provides severe sanctions against violators, including monetary. It provides possible repayment up to 3 times the amount if a false claim is made against government health care plan, and there's also possible civil penalties. Now, recognizing the right of competent adults to exercise choices concerning their health care, all 50 states and the District of Columbia have adopted some form of healthcare advance directives. Another aspect of avoiding lawsuits is to ensure that your respiratory license is active and that you're up to date with whatever your institution's practice, policies, procedures, and standards of care are. Even though you understand the national standards of care and clinical practice guidelines, you should have also documented attendance at continuing education seminars, just so that you know that what's going on and keep up to date in what's going on in your profession and anything new that's going on. Also, it's important to manage risk It should be done as an ongoing component of any sort of risk management program in your hospital, and also a good part of any sort of professional development. Large hospital systems have also suggested that active risk management practices and appropriate patient experiences policies are two of the most effective tools to prevent malpractice litigation, because unhappy patients are therefore identified quickly, and then corrective action is taken right away. So that way you're correcting your mistakes as soon as they're happening. A commitment to a great patient experience also produces listening to your patients, and then you're also making better clinical decisions. And then again, because of that, the patients are feeling like they're being heard, you're making less mistakes, and you're lessening your risk of malpractice lawsuits again. You want to make sure that because of you're doing these processes, you're developing good relationships with your patients, you're improving patient communication, and then because of that, your patients feeling valued, taken care of, they're feeling heard, and just that their overall experience is a good one. Here are some of the key points from today's lecture. I want you to make sure that you take the time to go over all of them. You're going to want to make sure that you understand everything listed in the key points, even if it wasn't covered in the lecture here, because it will be covered on the exam. And if you have any questions about today's lecture, please let me know.